All rise. Hear ye, hear ye. The First District Court of Appeal is now open. All who have business for this court draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. We are going to begin with the case of Sheryl and Brian Arbogast against Wells Road Veterinary Medical and so forth.
My name is Brian Lee. I represent the appellants, Sheryl, Arbogast, and Brian Arbogast. I'm going to reserve 3 minutes of my time for the roll today. As the court knows, this appeal comes to you from 2 motions to dismiss that were filed. The defendants in this case, defense veterinarians, as well as the company veterinary clinic that they work for. The trial court in this case found that a duty did not exist under the professional negligence count to warn the plaintiffs when their dog, at least as far as the well-fed allegations, have become violent and in their care. The allegations are going to be key, certainly in this appeal, because we are coming to court from a motion to dismiss and on summary judgment where the court would have had a benefit of evidence to make some sort of determination. The pleadings in the second amendment complaint, as set forth in the briefing, I don't believe is going to be contested by both sides because they are what they are. The pleadings set forth the factual scenario as to how the plaintiff's dog came to the veterinarians. They plead more specifically that it came to the veterinarians for care. The pleading also indicates that the dog Harley had never previously shown signs of aggression or attack or bite anyone.
Counsel,
Yes.
I'm trying to understand your argument here. You're arguing solely that the vet and the veterinarian company breached standards of professional care by not warning your client. Is that correct?
That is the issue on the bill, yes.
Okay, so you're not arguing that there was a failure to treat or there was a failure to give proper drugs which caused the dog to act the way it did. Your argument is solely, as I read the brief, the duty to warn.
It's limited to that, yes, sir.
Okay, just want to make sure.
Yes, sir. The failure to warn comes into play, obviously, the allegation, as I just mentioned. There had been no previous signs of aggression or attack when the dog was in possession of the veterinarian in this case and the clinic. The dog showed aggression. The dog showed aggression upon treatment, tried to attack the veterinarians, and they were only able to stop them from attacking by sedating the dog. When the dog was then given to the plaintiffs and actually was given to a person who lived with the plaintiffs, the allegations as pled indicated there was no warning that was given to either the person that they released the dog to or to the plaintiffs themselves.
What kind of warning do you have in mind? Would it have been enough to say, your dog may bite you?
Well, there's been the warning that we're looking at in this particular situation is that their dog had become aggressive to the point where they actually the dog tried to attack the veterinarian in their care. And the only way that they were able to stop the attack was to sedate the dog. So a warning as simple as, and really the warning is put into place, which is the treatment. If this is what we did for the dog, we tried to treat him, he attacked one of our veterinarians, we had to sedate him, he may attack without sedation, so you need to make sure to give him medication.
Isn't there a level of common sense with a sick dog may bite? Isn't that just common sense? And if so, why then would anyone have to warn anyone else that may happen?
The common sense argument certainly has been put forth by the defense, and I understand that argument. However, and certainly this court indicates that is common sense, that the dog may bite when they're sick. That's your decision. But we believe that that sense only goes so far. When we have a situation where there is an animal, certainly a dog, to the lay person, it may or may not be common sense that if a dog is sick, it's going to bite, or in certain situations, if you do something to a dog while they're sick, they're going to bite. That may be common sense, maybe not, but our pleading goes further than that. Our pleading indicates that if you take that premise and a dog that's sick could bite, well, then the veterinarian found out that premise was true, and that the dog actually did attack. At that point, the professional negligence standard, as we pled, and the duty that the veterinarian would have been to tell the owner of the dog that this dog has attacked us in our care, and you need to be careful.
Hone in on that then. If I understood the pleadings correctly, the dog, your word, attacked the veterinarian when he was palpitating the dog's stomach. So would that be the extent of the duty to warn, that if you are palpitating the dog's stomach, he may bite you, versus whatever happened in this case, because I understood the allegation simply petting the dog?
Yes, sir. And that, ultimately, that could very well be the only duty that's there. I think ultimately what would happen is, let's say the veterinarian did say that, and said that when we tried to touch him or palpate him, he attacked us, so don't do that. And then later on, they weren't doing anything, the dog just attacked them. Is there a duty? I think in the circumstances of this case, and also from other cases, that duty and whether there is some type of causation through that is going to be something that would not be able to be dismissed at a motion to dismiss. It would have to go through pleadings, it would have to go through evidence, and there would have to be a determination by either the judge's summary judgment if he felt that that was appropriate, or at a trial with the jury.
But isn't the question of duty a question of law?
Yes, it is.
So, isn't then that issue something that could be determined in the motion to dismiss, since it's a pure legal question based on the allegations of the complaint?
It could be determined, yes, by the trial court as to whether a duty exists in the first place. As far as how far that duty extends, which would necessarily be determined by the allegations of the complaint, the factual allegations, that's where it would turn into more of a situation where you have to have the facts fleshed out to do that.
Now, you argue very well in your brief that the case we should be guided by, or one of the cases, is the O'Keefe v. Oregon decision, where this court said that a mental health professional had a common law duty to warn the parents of a child, but only because the professional had a relationship. The parents were also patients and did not extend it to third parties. Explain how that principle applies to a veterinarian and a dog.
Yes, sir. And obviously, you can go to the O'Keefe case, which you certainly succinctly put. How this translates to a veterinarian situation as we have here. The plaintiffs were the owners of the dog. So they were, as the minor parents were in the O'Keefe case. The minor was the one that was getting the treatment. He was the one that was, and ultimately was the person who perpetrated or killed the father in that case. How it becomes relevant to this case is that the holding in O'Keefe held that implicit in the right to consent to treatment by a physician in that case. was the right to be fully informed as to what was happening with the patient, in that case was the minor. And the duty to disclose the information and to warn was present, that this court found was present in that situation. How that translates to our situation is that the plaintiffs sent the dog to the defendants for treatment. They consented for that treatment to be done. So when they received the dog back, they were entitled, just as in O'Keefe, to right to be fully informed about that treatment, and they were not. They were not told of the incident that occurred, at least one that we know of, that occurred while that happened. And that is how it brings it into that auspice of what O'Keefe was talking about.
If Harley had bitten somebody other than the owner would be responsible for any injuries that resulted by statute. Isn't that right?
If I understand you correctly, you're indicating that if there was no veterinarian present and Harley was at home and then bit someone, is that the situation you're in?
Well, I don't see how it makes a difference whether or not Harley had been to a veterinarian. Say the neighbor came in and got bitten. That's in the owner's legal responsibility, right?
Yes, under the strict liability statute, the owner would have liability to a neighbor who came over and got bitten. What's different, even in the strict liability statute, there are exceptions carved out, and one of them is negligence, where there's any comparative negligence of the person who got bit. But then there's also a concept of maybe a third party type of person who could be negligent, the typical type of fabric, I guess, defendant. So if you say that the veterinary care was done in this case, dog is sent back home with Mrs. Arbogast, and maybe a neighbor came over and that was the person who got bit, I think we're still dealing with the same situation, although now the neighbor may have a cause of action against the owner as well. There could be a flow of the negligence from the veterinarian onwards to a claim for the neighbor in the same situation where there was no warning given to the owners.
But didn't O'Keefe refuse to extend the liability of the medical professional to the third parties? I mean, it seems to me the Tarasov case, the California case, that basically said, created a duty running to all potential victims. Florida law, starting with Boynton and O'Keefe, doesn't extend that duty to all third-party victims. Isn't that correct?
That is correct. That's the state of the law at this point. I'm just saying that depending upon, ultimately that may be the case, and I'm trying to answer the hypothetical here, that it ultimately may be the case that case law comes into point with that third party. But again, we're not dealing with that situation. We're dealing with a very direct type of action here of the owner owner in this case against the veterinarian.
Do you have a veterinarian case? Do you have a case where a veterinarian is liable for failure to warn somebody that dogs may bite?
I don't believe there is a case, Your Honor, that goes specifically to that. There is a case that I cited in my brief, Smith versus Hugo, although that is more of a procuring opinion. It's already at the point where there's a trial based upon the negligence of the veterinarian in that case where an owner was bitten. So
the owner was present at the veterinarian's office trying to help hold the animal on the table.
Yes, sir, that's correct. So there is no case I found that deals specifically with the situation, or certainly I would have put that up to this court. But I'm in my time.
All right, we'll hear from you again on the vote.
My name is Attorney Ken Lasky. I represent Dr. Arbogast only in this matter. My co-counsel here represents Dr. Harris as well as the veterinary clinic. And I would like to reserve 5 minutes for my counsel to address that issue as well. If it may please the court, what I would like to start with initially is my client was not discharging vet. So even if there were a duty to warn, that duty clearly does not apply to a non-discharging veterinarian who can't possibly provide a warning when they are not the ones that discharge them. I think you will find that is the only distinguishing point that either me or my co-counsel will make on this matter. As this court correctly stated, the existence or non-existence of
Is
duty.
the status of your client as not the discharging vet reflected within the four corners of the complaint?
It is not, Your Honor.
So isn't that issue premature to address at this stage?
It is, Your Honor, and like I said, that's the only thing that I wanted to throw out is that it was it is a separate issue, and that's the only distinguishing part between the two of us. Okay. As this court again correctly stated, that the existence or non-existence of the duty is clearly a question of law, and as a question of law, it is properly and rightfully dealt with as a motion to dismiss. What counsel was trying to state as far as the extra pleadings and things like that to go to how far a duty may or may not extend, that may very well be a question that requires facts, evidence, and go through that should be dealt with at a later stage. However, the bare threshold question is there or is there not a duty? And that is a proper question that can be addressed on a motion to dismiss. And in this case, it was. This court in Aguila versus Hilton, that was a case involving a security guard who walked by a room and he saw there was an injured person on the floor, there was a bunch of intoxicated teenagers. The security guard cleared the room and asked everybody to leave the property, even though he knew there was intoxicated teenagers in that room and some of them might drive. This court found that no duty existed, even though the plaintiff wanted to have a duty because the duty would be too broad that the security guard would then become an insurer, and the only thing that it could do is impound all those teenagers and maintain them all on their property. The court refused to find a duty. Again, as I said, that would be way too broad. Very much like in this case, if a veteran has a duty to warn that a dog might bite, or a sick dog for that matter might bite, as you properly stated, I believe that is common sense. Sick and injured animals do lash out. The reason that Florida has imposed strict liability on animal bite statutes is even the sweetest, most loving animal can and will bite without provocation and without warning. There's no signs that the dog's going to bite. Sometimes they just bite. And that's what happened in this case, unfortunately. Now, counsel likes to mention that when the animal was in the veterinary's office, that the animal attacked when palpated. What would the warning have been? Hey, if you palpate the dog, it might bite you. But that wasn't even alleged in this complaint that they palpated the dog and bit him. It was alleged that when they walked in the room to give the animals medicine, it attacked them. So this becomes now an overbroad warning that anybody who brings an animal in, it might bite. Now, this court brought up the Smith versus Hugo case. This is a totally distinguishable case between that and Smith v. Hugo. Smith v. Hugo is a case where there is a common law.
Do you have a case that says it's an open and obvious danger that a dog may bite or a sick dog may bite?
Your Honor, what I would say is for the open and obvious is in Jones versus Hugo Mutual Insurance, which is 463 Southern 2nd, 1153. It was in that opinion. Dogs bite, bark, chase, jump. They can be vicious and rambunctious. It's all inherent within the breed. And a duty only arises to warn outside in the common law area dealing with an animal if the defendant is in control of the danger, if the defendant is in control of the premises where it happens, or if the person, or if you take the dog out of it, or that is the person who committed it. The veterinarians in this case, neither my client or co-counsel's client, had none of those in this case. That animal was released from custody and in the pure custody and control of its owner. We can't have a duty to continue to protect them when we're not there.
But didn't the O'Keefe case reject the control element by saying that it's really a foreseeability issue? And in that case, they found that at least there was a cause of action stated against the mental health professional. Why isn't O'Keefe persuasive here?
The reason O'Keefe is not persuasive here is in O'Keefe, the psychiatrist has specific knowledge of the danger. He has specific knowledge of the actor. He has specific knowledge of the target. In this case, it's more like the crystal ball case that was mentioned in in Boynton, where the psychiatrist doesn't know what may or may not happen. That's why Boynton originally rejected Tarasoff, is you're asking way too much of it. Now you're dealing with a veterinarian who's dealing with a non-communicating animal, and you're asking him to know that this animal is going to not only attack, but who this animal is going to attack, and who to relay that warning to. I mean, that's just way overbroad.
Well, is it really that broad in this case? Isn't the party to whom the warning should be given really have a patient relationship with the vet, because the dog's a dog, so it's the person who owns the dog who has a relationship with the vet. So that's really the limit, I think, that we're seeking here, which is different from Tarasoff, is different from Boynton.
Well, Your Honor, I would agree with that to a limited extent, whereas if this was an animal who, from the moment it came into the vet's office till the moment it left that office, was attacking anything that came near it, at it, touched it, looked at it, then they might say, hey, you have an animal with behavioral issues here that need to be monitored. However, a one-time animal turnaround attempting to bite when they touch it or it's sore, I mean, I think any of us have been to the doctor, and if the doctor touches you in a sore spot, you're going to jump and react. Dogs jump and react differently, and they might bite.
Now, if you're not saying there's not any duty to warn, you're simply saying since dogs bite, there's no duty to warn about a dog may bite. So, for example, if this dog had a communicable disease, you would concede, I think, that the vet would have a duty to warn that the dog may, not to have other animals around the dog if the dog was going to.
Absolutely, because with a communicable disease, that's something that as in some of these other, where the statute entails, like an AIDS case, it's verifiable independently by a separate test that yes, this animal has problems, say rabies, for example, and wouldn't be released, but if it has some kind of communicable disease, then yes, the only person who would know that disease would be the veterinarian. And absolutely, the veterinarian has a duty to tell the owners of that animal that if it was diagnosed with this certain thing, you need to keep it away from these other animals, from these other people, so that's a custodian. And if that were the case, I would absolutely agree that there is a duty, because that's inherent in the treatment. Warning that an animal might bite, that's not inherent in the treatment. Animals bite, specifically dogs. It happens all the time. That's why Florida has gone away from the foreseeability issue as it pertains to dog bites with the strict liability statutes, and that's why they're there. And what you brought up earlier, Mr. Justice, was would it, if this dog had attacked a neighbor, would the vet be liable at all? Absolutely not. The owner, clearly by statute, is 100% liable. Now, with the comparative negligence arguments, as he mentioned, they go to, was the person antagonizing the animal? Was the person, did the owner have a signpost saying, bad dog, and they came on anyway? None of those happened here. This was an instance where the owner walks in the room to give the dog its medication, and suddenly, without warning, it attacked. The allegations in the complaint don't even allege a duty to warn in there. They allege the improper medication is that and the other. They assume that there's a duty in this matter, and the duty just doesn't exist.
All right, now they've conceded that the only thing they're pressing on appeal is the duty to warn.
Correct.
Your position is that the complaint does not allege a duty to warn.
It specifically does not allege a duty to warn. I think that it was assumed within it that there should be that duty to warn, and that's what caused it. And again, in Lovac versus, I think it was Mallory, 14 Southern 3rd at 1090, there's no duty to warn about obvious natures. And as I said, when we get to these issues, dogs bite. That's why the dog bite statute is what it is. It's an inherent risk. You can't warn about an obvious danger. If vets were required to warn that any animal that they saw at any point in time may bite, it becomes a wasted warning. Hey, your dog might bite.
Well, the complaint doesn't allege something that broad. It says the vet knew the dog had a tendency to attack when in pain, because it did, and then that the defendants were negligent because by failing to communicate or warn plaintiffs regarding the fact that Harley's condition had now become so painful that the plaintiffs would be in danger of being attacked if Harley wasn't sedated. So it's a very specific allegation.
Well, I would say that in O'Keefe, if there was a single warning by the minor that, hey, I'm going to beat my dad up, and nobody was warned, and that attack happened, I would argue that this court would have denied to express view that law. The reason this court went where it went with no view is because this wasn't a single isolated one-time incident. It was built over and over and reiterated time and time again. And when the plaintiff's let here's a one-time incident.
You're to the time, what to reserve for co-counsel.
Thank you.
May it please the court, my name is Michael Clark, and I'm here today on behalf of Wells Road and Dr. Harris, as asked specifically that the court affirm the dismissal of the Second Amendment complaint with prejudice. I'm going to adopt the arguments of my co-counsel and use my time to specifically focus the court on the footing that this case appears before it. But the complaint says, and importantly, perhaps what it doesn't say, Ms. Arbogast did not drop this dog off at the vet. And I think what duty to warn comes down to some sort of communication between the veterinarian and the client. I think that that's what the plaintiff is pressing at. She also did not pick the dog up at the vet's office. There is absolutely no allegation in the Second Amendment complaint of any contact or communications between the plaintiff and Dr. Harris. So what we have here is, again, looking solely at the four corners of the complaint, another resident of the Arbogast household dropping the dog off and being specifically advised upon release that the dog was in severe discomfort and given pain medication. And when Ms. Ryan, the co-resident, so to speak, picked the dog up, she was advised that and was provided with medications and discharge instructions for the dog. And at that point, the dog is released to the custody and control of this, I guess, the plaintiff's agent, if you will, and given the dog. There's still one more important point about what the complaint does say is that the defendants didn't provide a specific, definitive diagnosis of the dog's painful condition. So looking at the four corners of the complaint, we have someone here who has knowledge of the idea that the dog is sick, on medication, injured, and we still don't really know why. That's the four corners that we're faced with. And I would go with the Copeland's and common sense argument that let sleeping dogs lie. That what has happened here is that this sick dog bit its owner while in the owner's exclusive custody and control at the owner's home. And I will return to Clark versus Boeing, which is a...
It could have a different case here, which would be making a different argument if the dog bite, if the owner was bit after rubbing the dog's stomach or palpating the dog's stomach, the exact same conduct that led to the attack in the vet's office.
No, Your Honor, I would not have it. My argument would be the same. And Judge Schwartz's concurring opinion in the Clark versus Boeing case, where they determined as a matter of law that concerning duty to warn, that Professor Prosser said there's no duty to warn that a knife or an axe will cut, an axe will take fire, or the dynamite will explode. And I would submit under the same facts, whether you're palpating the dog, when you are dealing with a sick animal, you have to be aware of the fact, regardless of if there is a warning or not. And I submit that there should not be a warning, or that we should not, this court should not impose one to do that. It is an issue that can be determined as a matter of law, and the trial court did do that specifically in this case. And I will also say, Judge, just you were part of the concurring opinion in the case cited by co-counsel, the Aguila case, where this court determined as a matter of law that there was no cause of action because there was no duty to warn that a drunken teenager who was involved in a tragic accident taking someone else's life, that there was no cause of action there. And what the court, I believe, focused on under the McCain versus Florida power analysis is the foreseeable zone of risk. I think what you focused on in that opinion was the ability to control the risk. And once that animal is placed in exclusive care, custody, and control back into its owners, there is no duty. There is no longer any duty, and there certainly isn't a duty I'm out of time, but that's the best I can do in response.
Thank you, Mr. Clark. Rebuttal.
Thank you, Your Honor. I wanted to, both counsel want to discuss the Aguila case, which Judge Member was concurring on that opinion. And I just wanted to point out that in the opinion itself, it says the main difference between this case and many others in which the courts have found a duty is that there is no relationship between the defendant and the plaintiff. That was the main focus of this decision, of the relationship. And they found that because the security guard didn't have this relationship with this student that would impose that type of duty, that they weren't going to find a duty in that case. We have something completely different. I don't think there's any argument that there was not a special professional relationship between both the plaintiffs and the defendants in this case. So we feel that this case would be taken out of the Aguila context because of that relationship.
How do you respond to counsel's argument that the plaintiffs here, and I think they go to this point you're arguing, were one step removed from the defendants because there was this intermediary roommate who dropped the dog off and picked the dog up?
Yes, sir. I would respond, actually, and I think the way that they ultimately responded, which was that this person, Lisa Ryan, who was a person that would be acting as defendant agent in that case, or excuse me, plaintiff's agent, they sent her to get the dog. If there had been a warning given to her, and she didn't translate that to the plaintiffs, then I think we'd be in the same situation, although there may be an additional defendant in the case. I don't think that matters, and what the talk about the allegations in the complaint, I think ring hollow to the court because that's not what they were seeking in the motion to dismiss. The motion to dismiss was specific to the duty. It wasn't that the allegations weren't specific enough, or that the allegations were confusing or anything. So that was what was ultimately appealed, and that was what was determined below. And I would ask that the court reverse the order and send it back to the court. Thank you.
Thank you, Mr. Lee. Return now.